It's April 2024 and court is sitting in the mystery town. Remember, I'm not naming the town. It's a great regional town like many places in New South Wales. I'm making this at Windsor Local Court. It's the oldest continuous local court in New South Wales. I'm in northwest Sydney along the Hawkesbury River, which is just recovering from another flood. I acknowledge the Darug people as the traditional custodians of the Hawkesbury and pay my respects to elders past, present and emerging. Windsor Local Court was built in the 1820s. It's a colonial Georgian style and it's a Francis Greenway design building. Greenway was an English architect who was transported to Australia as a convict. His crime was forgery. He was honoured on the $10 banknote. There's also a jail near Windsor named after Greenway. Anyways, he designed significant buildings within years of arriving, including the Supreme Court in Sydney, as well as Windsor Local Court. But is this the mystery court? Windsor is part of a court circuit with Katoomba Local Court. Generally, the court sits at Katoomba in the Blue Mountains on Monday and Wednesday every week, and then it sits here on the Wednesday, Thursday, Friday. So no, not the mystery court, because the mystery court only sits one day every second month. Windsor, like other local courts, is pretty busy. They can have 50 to 100 cases listed here per day, and they also hear cases from the Children's Court as well. Of course, as I've explained in the previous parts, I go to the mystery town to hear cases from a typical regional New South Wales town for the purpose of discussing the concept of deterrence. On this day in April at the mystery town, there are 15 defendants on the list to appear. About half are present and they are adjourned to the next court date for various reasons. For example, seeking legal advice or completing the traffic offenders program. The other half aren't there. Some are dealt with in their absence, but the rest, it's not really clear where they are. So about an hour in, there's only one defendant left, and it's the case I'm going to discuss in this part. However, I can't really discuss deterrence because it didn't end up being a sentence. Instead, I'm going to make some observations about the proceedings. One of the main reasons I'm going to just talk about proceedings in general is because this case involves mental health issues. I don't feel comfortable discussing some of the finer details about someone's mental health. I think health conditions are a private personal detail and I want to respect the person's privacy. So I'm only going to discuss the parts that are relevant to the community. With that said, I'm not actually going to say the circumstances either. I feel the bits I heard from the gallery were only part of a complex story, so I don't want to just say a piece of the story. The offences occurred a year before. The court was clear that what occurred would have been quite a terrifying experience for the community members involved. Today, the defendant is seeking a Section 14. Now, this won't be explained to us in the gallery what a Section 14 is. What they mean is the defendant has made an application seeking a diversion under Section 14 of the Mental Health and Cognitive Impairment Forensic Provisions Act 2020, and we're in New South Wales. A diversion means their charges will be dismissed and they will be diverted into treatment. This doesn't mean they're going to be locked away in hospital. It's more likely a treatment program where they see a doctor regularly and have some medication. What the court needs to work through is, does the application meet the criteria? So there's lots of reading of medical reports, meaning there's a lot of silence in the gallery. The court decides that the defendant does suffer from a mental health impairment. There are details and discussion of the mental health issues and their mental health history as well in open court. However, I'm not going to discuss those details. What's important is the defendant is eligible for diversion under Section 14 because they suffer from a mental health impairment. So next, the court needs to balance the need to protect the community and the treatment of the defendant. They are trying to get those two goals to occur side by side. My first observation about proceedings is time. I thought it was beneficial that the court had the time to go through the documents, discuss the issues and identify measures and conditions to protect the community and see that the defendant gets treatment. They had the time because the other defendants had been dealt with and the remaining defendants, well, who knows where they were. So it was just me and the sheriff sitting in the gallery. Sometimes at courts, even before they start at 9:30, you wonder how on earth the court is going to get through the court list by the end of the day. They are so busy. My second observation is about solicitors. I thought it was beneficial to the proceedings that there was a solicitor involved. First, I actually think being unrepresented is perfectly fine. Sorry, solicitors. However, this was a complex legal process. I thought the contribution from the defence solicitor, as well as the contribution by the police prosecutor, assisted the magistrate in working through the case. They were across the different intersecting laws. For example, because there wasn't going to be a conviction, the court didn't have the power to order compensation. The police prosecutor was pointing out the relevant parts of the law to the magistrate, but the defence solicitor was prepared and suggested solutions. They put forward that the defendant would compensate for damage anyways. This meant the magistrate was satisfied they followed the law and the community was compensated. Now, this solicitor was the only one there either representing people or giving advice. As you guys probably know, when a solicitor starts their appearance, they announce the case and then they say, if it pleases the court, my name is, and then their surname. I noticed on this day, this solicitor included in their initial introduction to the court that they were the legal aid solicitor. Solicitors typically do an introduction once and then they just do the case after case until they are asked to be excused. Of course, if they come back later in the day for more cases, they'll probably do the introduction again. Anyways, I'm going to make an assumption that the solicitor was provided by legal aid for this case. First, it's great that regional areas have access to legal resources, just like in urban areas. I wondered if the outcome would have been different, but for the resources provided by legal aid. Would there have been that high level of advocacy if those legal resources weren't there on the day? The last observation I will make is about the behaviour of the court officers, in particular the personal approach. Now, it's not written anywhere in the law that any officers of the court, that includes solicitors, give like a personal touch when being involved in a case. I thought the legal proceedings benefited because of the small personal touches shown on the day. Let me explain. On this day, I saw the defence solicitor rearrange the chairs so the defendant was sitting closer to them. Just some context, defendants in cases like this will move out of the gallery to a chair, usually behind the bench where the solicitors are, meaning they leave the gallery and the people who have come to support them and move forward into a space where they sit by themselves. It's a very small courtroom in the mystery town anyways, but this meant the defendant was even closer to their solicitor. It was just the small gestures I thought kept the defendant calm, assisted them in following what was going on, etc., etc. A solicitor doesn't have to do this. I think that personal touches are more obvious in regional areas, but they do happen in the urban courts. Maybe it's just harder to see in the urban courts because of the crowd. Actually, I saw this type of behaviour only a month before. I was in Raymond Terrace Local Court in March, and there was also a Section 14 application. Raymond Terrace is busier and the defendant's chair is in more open space than here in the Mystery Court. In this case, the Section 14 was refused as the court found they didn't suffer from a mental health impairment and therefore not eligible for diversion. This meant the magistrate gave a long explanation into the decision making. The defence solicitor left the bench during the explanation and went and sat next to the defendant. The solicitor may have whispered a couple of things to the defendant, but they mostly sat in silence and just listened. I felt this was a personal touch to support the defendant through the experience. Court can be an intimidating place. I think, and you can disagree, a defendant who is calm, informed, and engaged in the process is likely to be beneficial to legal proceedings. I saw this at the Mystery Court. Sometimes issues popped up during proceedings and the defence solicitor needed to think on their feet. This might mean quickly asking the defendant what do they want to do right in front of the magistrate. For example, the magistrate wanted to condition where the defendant was going to live. Therefore, there was some quick back and forward. I felt a defendant who was calm and following along could make informed choices, give the instructions to the defence solicitor, and the proceedings could keep moving along. By the way, I've also seen these types of personal touches from magistrates as well. No, they don't come and sit next to the defendants. What I mean is I've seen them say things like give a little bit of extra context before delivering a sentence. The example I'm going to give is actually from the day before I went to this mystery town. It was a sentencing in Kurri Kurri Local Court, which is near Maitland back in the Hunter Valley. It was a high range drink driving case. The magistrate wanted to make sure the solicitor had fully explained the process of what was about to happen before they started the sentencing. Basically, for the first couple of minutes of this sentencing, there was going to be a lot of references to jail before they actually got to the result, which was, in this case, a fine. I have seen it is usual in these types of high-range drink driving cases that the magistrate deliver a firm, serious, slightly terrifying sounding reality check that involves going through how much the defendant is at risk of going to jail, as well as dying or harming other people. What I'm saying is I've seen these types of personal touches that I think goes to considering a person's well-being in court. In summary, I thought time, legal resources and well-being were beneficial to the legal proceedings on this day in the mystery town. Other than that, I spent a lot of time in an empty gallery. At one stage, a group of bikies arrived. All you could hear in court was the revving of the bikes as they drove past. I wasn't sure if they were the missing defendants, but no, they were just lost tourists who had taken the wrong turn and come up the street to the court rather than onto the scenic route which runs through town. Being April, the weather is getting a bit fresh. I haven't quite reached for a jumper yet. However, I'm thinking it's definitely coat and beanie at the next court date in June at the mystery town. Maybe I might even sneak a blanket to keep warm in the gallery. I'll keep you posted.